All right, I have 2:49, and so we will reconvene our meeting. I understand from Margaret that Dan Clark has a friendly amendment, so she will express that, and then we'll see what the maker and the second think of it. All right? Margaret.
Friendly amendment from Dan Clark. I would like to offer what I would intend to be another friendly amendment to Hunter's motion, and that we recommend to the Supreme Court to look at a broader review of all of GR 12, not just 12.2. Excuse me. I am also in agreement with Andre and others that we recommend to the Supreme Court that the relevant provisions of GR 12.2 does apply to the Supreme Court boards to avoid any ambiguity going forward. I like Chief Justice Fairhurst's earlier comments that we ask that the court take a review of GR 12 and the various provisions in connection with all of the issues this work group has been discussing, that we also provide the court with the various other options, such as Michigan, etc., for their potential consideration and or adoption.
Okay, so I view that as friendly amendment to what is now the first motion and support of the third motion, and a suggestion that I don't think necessarily has to be part of the motion, but that I expressed, which is having the report identify the different options that we considered but did not take a vote on, so the court has the benefit of all the different suggestions and also concerns expressed about those and how they could be misinterpreted, or being clear that no intent at all to affect access to justice or diversity, and to the extent it was viewed as that would not be what was coming from this group. Okay, hopefully, Dan, if I'm not accurate in my understanding of what Margaret read, I hope you'll either send another email or make noise, and I will call on you. Dan, were you starting to say something?
I know that's accurate. Though. Thank you so much.
You're welcome. So, Hunter.
So I will accept that friendly amendment. One item I would note here is that there's kind of a sweet spot that I've been aiming for, I think maybe unsuccessfully so far, between too detailed and too high level, in the sense that if it's so high level, we just recommend that the court think about this. I'm not sure how helpful that is to the court. So I do have some concerns that we're heading down that path, but acknowledging that, I would accept the friendly amendment to change it to a broader review of GR 12.
Okay, and is that all right with you? Eileen says yes. Kyle, speak.
So I'm still troubled with the word heightened, and I'm wondering if we were doing the amendment, if Governor Clark's amendment takes that out of it, or does it amend it and adds to it?
I didn't hear him say anything about heightened.
Right.
I heard him only talk about the boards and giving the options like directly, Michigan, et cetera.
But the original motion was heightened.
That's still Hunter's motion. Did you hear Dan Clark say something different?
Well, but it's an amendment to it.
It's motion one, because we now have three motions.
Motion one.
So motion one is GR 12 broadly. Motion two is 12C2
Got it.
heightened. Motion three is 12.2C or C2 to apply to the boards. So I have three motions, so I only heard him amending one.
Understood. Thank you. That clarifies it for me.
Okay. 12.2C. Well, no, okay, that Hunter's motion is 12.2C2,
That's motion number 2. That's correct.
not just 12.2C.
So sub 1 and sub 3 would not apply to the court-appointed boards, is the motion?
No, that's a separate one.
That's the third motion,
That's
the question of
the
the
third
applicability of the boards.
Right, that's what I'm seeking to clarify.
I'm sorry, my intention would be that 12.2C in its entirety would be applied
That's
to
what I thought.
To the boards.
Thank you. Yes.
That is the third motion.
Yeah.
Okay? All right, so good to go. I'm going to go ahead and call the question. I think we have discussed. I would like to hear from those in attendance, and I would also like to see if there are other motions. So I'm taking motion 1, which has been friendly amended, to recommend to the Supreme Court that they revisit GR 12. All those in favor, raise your hand. 2 1/2, 2. Those opposed, 3, 4, 5. Okay. Jane and Dan, your votes? Jane?
I vote for.
3. And Dan?
Okay, yes, 4, please.
He is also 4. So I have a split of 4 to 4.
4 to 5.
4 to 5, okay? So that motion fails. I'm going to the second motion.
We were getting closer. The last one was 6-4.
You are, and there might yet be another motion, but a friendly amended motion fails, 4 to 5. 12C2, a heightened relationship between the issues and the practice of law or the administration of justice. All those in favor, raise your hand, please. 2. Those opposed? 5. Jane, your vote?
4.
And Dan, your vote?
No.
So I have 3 to 6, losing ground. All right. Motion 3 is 12C2, applying to the Supreme Court appointed boards. Yes, please. I'm saying it wrong.
12.2C in its entirety.
Thank you. 12.2C in its entirety, applying to the Supreme Court appointed boards. Everybody clear on the motion? Those voting in favor, please raise your hand. 3. Those voting against in the room. 4. On the phone, Jane?
4.
And Dan?
Yes, 4.
5 to 4, it passes. So 1 has passed. Are there any motions related to GR 12 before I move on? Hearing none, we will reflect that these motions were made, what the votes were, and that'll be part of our report. The recommendation that is being added is the final one, okay? It's going on 3 o'clock right now. I'm going to open up, we're scheduled until 4. I'd like to open up the floor for up to 20 minutes. So if you take too long, no one else will get to speak. If you don't have things to say, or we're done before 20 minutes are up, we will go back to the work group discussing recommendations and taking votes. Nancy, you may be first. And I do want to thank you all for, many of you have attended all of our sessions. I know people are listening in on our sessions, those who have even just attended only today. We appreciate your presence and your participation and your attention. Nancy, you're first. And why don't you identify yourself again?
Sure. I'm Nancy Hawkins. I am a member of the Family Law Executive Committee, their liaison to the Board of Governors, and I am a family law attorney here in Seattle. And I had several points I wanted to make. And first, obviously, thank you to the group for all of its hard work. I have found this to be fascinating, both listening to the conversations, reading the materials, and listening to the speakers. Very informative, and have been doing my best to keep my section informed. I wanted to address one of the points that was made, that a section had some groups split off, and that is the family law section. We faced some great challenges dealing with what I call the Central Bar Association system. And a couple years ago, a number of people on our executive committee resigned as a group and formed a separate organization called DRAW. And that has had an effect on our section, in that there are a number of people in the membership who somehow believe we don't exist anymore, or that we only exist in this other form that isn't controlled by the Bar Association. And so if there's any doubt about that, the family law section is alive and well. We are still doing our excellent work in statewide CLEs and materials and trainings for lawyers and all the things that we do. We did have a little blip when we lost half our executive committee, but we regained our footing and have continued. And we believe strongly that the strength of our sections is the strength of this organization, and that everything must be done to defend them. I listened carefully to the discussions about social issues, and I have to say that I find the use of the term social issues to be a minimization of the importance of those issues. The question of expanding marriage to same-sex couples is not a social issue. It is a important family issue for gay people in this state, and now for the entire country. And death penalty is not a social issue. If it is your son who has a developmental disability and no income to hire or assets to hire a lawyer and is facing the death penalty or lifelong prison, when someone like Jeffrey Epstein gets to go on work release in his limo. These are life and death issues for the people involved. They aren't social issues. So I would urge that we not use that phrase. There have been other comments. I read the comments that people submit about the concern being over divisive issues. Every issue is divisive. There is not a single issue that this organization ever looks at that is 100%. As Doug could verify, there are people that don't think we should discipline lawyers if they murder people, if they steal money, whatever the wrongful things that can happen. There are people that think that you should be able to practice law without a license altogether. So we don't even have 100% agreement on that topic, let alone on any of the myriad of other issues. This organization does events that I disagree with, that I don't think are good budget decisions. That doesn't make them structural decisions, but there is disagreement. There will always be disagreement. There will always be, as a result, divisive issues. All of the motions, Hunter's motions, et cetera, that seem to talk about controls on what we can do. Let's have a more direct requirement. Let's have a more strict scrutiny. Those are all designed to lessen what we do, to look at what we're doing now and say, well, maybe we need to do less of it or not do it at all. And we heard a lot about access to justice, and I love the reassurance from the court about that, but that wasn't always what we did. And as we learned from some of the speakers, plenty of bar associations across this country do not do any of that. So we should be proud of the things we've been doing. Not all of them. Some of them I disagree with again, but these kind of access to justice issues, diversity issues, are things we should be proud of. And we should be defending them with that pride, not trying to put in some words that somebody else can use as a reason to find those programs not supportable. What is a political issue? Obviously, who we support as candidates, that's political. But just because people disagree about a topic doesn't make it political, and therefore we shouldn't take a position. 150 years ago, slavery was a political issue. If you don't take action against, you don't take a position against something like that, then you have taken a position in support of the status quo. Putting Japanese Americans in camps during World War II, that was a political conversation. It didn't make it right. It didn't make it something we shouldn't have been involved in, which we finally did, I think, about a year ago to say, gee, that was a bad idea. But the fact that it was political to begin with, that it's in the political arena, should not make it prohibited behavior. Now, I agree that sometimes a topic comes up, and maybe it's a hot topic. Most recently, the death penalty was one of those. And if the organization decides that taking a position in opposition to it was too much, because there were too many members opposed to taking that position, the organization can still take a position in favor of education. Here's the topic, here are the pros, here are the cons, here are the people affected, here are the reasons why, and then let people make their decisions. Family law has to address, the Family Law Committee faces sometimes 100 bills in the legislature each year on family law matters. We want to take positions on all of them. They all affect the citizens of this state in some way. They all affect the courts, because every divorce has to go through a court. And sometimes our position is, this is what will happen if this gets passed. This is what will happen if it stays the same. And sometimes our position is, and therefore it goes one step further and says, and therefore we want to oppose that bill. But there are times where we can just play an educational role, and that shouldn't be viewed as somehow some sort of prohibited political action. Everything in the legislature is voted on by politicians. That makes it political. But free us up to keep on doing what we have done in the past and what we want to continue doing, but don't make us leave the organization to do that. Let's keep this structure together like we decided, a month ago, that would be the recommendation to the court. And be proud that our section and other sections are so willing to do so much work. And as far as the concern that we're only Seattle Central, our Family Law Executive Committee has members in Vancouver, all the way up to Snohomish, in Spokane, and places in between. Depending on the year, lots of places in between. And we fly and get together and have meetings across the state all the time. All sections can do that. In fact, we probably do more of that than the boards, the Board of Governors sometimes, Supreme Court, certainly. Just because somebody writes a letter isn't a reason to throw everything out because somebody wrote a letter. I read one of the comments, and it talked about how we were doing, mandatory sanctioning of CaseMaker, completely disregarding, for example, the fact that the board actually approved a second research tool as well. The vast majority, if not all of the people that write these little isolated comments are uninformed. Let's not throw out informed decisions and programs we're proud of because a few uninformed people write a couple emails. If anyone has any questions about the strength of our sections, have our sections come and talk to you at a meeting. Let's not rely on someone else's version of the value of sections. We are happy and proud to tell you what we do and why it's not, shouldn't be prohibited political or reduced to social issue commentary, but in fact is valuable work for the state of Washington, for the lawyers of the state of Washington, for the courts, for our entire state.
Doug Ende. I'm the Chief Disciplinary Counsel at the Washington State Bar Association. I've been keeping my powder dry for a long time. I've been here since the first meeting. I've attended in person most of them, and I thank Chief Justice Fairhurst for giving the attendees an opportunity to address the work group. I will endeavor to be brief. I genuinely think that there was a missed opportunity here, an enormous missed opportunity to seriously engage with the question of whether there might be a better structure for the organization, apart from whether the United States Supreme Court may or may not someday require it, or some federal court may or may not require it, but whether it is just a better, more prudent and appropriate idea to restructure in some ways. And I've been asking myself, why wasn't there that deep engagement with a fundamental question? And I think part of it was confirmation bias, and that's fine. We all struggle with our own confirmation bias, and that's just a fact of human nature. And I think it struck me today, maybe for the first time, that there was another dynamic going on, and I wanted to share it with you. And I believe that the idea of a more substantial restructuring of the bar, dare I use the B word, a bifurcation of the bar into a regulatory agency and perhaps a voluntary statewide bar association, that would if that path were to be walked, then important programs important to some of the stakeholders here, access to justice programs, diversity, equity, and inclusion programs, would simply be sloughed off to the statewide voluntary organization to be done or not done, perhaps, and that funding would be lost. It couldn't be funded through mandatory licensing fees, and that would be tragic, and indeed it would be tragic. However, I think that was a red herring. That never would have happened because, as Andre Lang has pointed out, it's embedded in the regulatory objectives that the Supreme Court has already adopted. Those are the Supreme Court's requirements for regulators ensuring access to legal services, ensuring diversity and inclusion among legal professionals, even if the regulatory functions were being discharged by a regulatory agency, those would still be the marching orders. So the irony, to me, is that the group, partly through fear of losing, I think a false fear of losing some important components of what the organization does, has settled on a structure that is less protective of the public, also a regulatory objective, less protective of consumer interest, also important regulatory objective. I've been around, and I'm not speaking officially on behalf of the Office of Disciplinary Counsel at the bar now. I'm just a guy who's been at the Bar Association, I can say, for decades now, and seen it up close. And many times I've come before the board with recommendations that I believe are important public protection measures, or would increase access to justice, would improve consumer legal services on behalf of consumers, and arguing, whistling in a hurricane while standing next to an empty chair, that empty chair being the public. So I've many times found myself arguing as Chief Disciplinary Counsel, as a lawyer, about what that empty chair might have been saying in that moment. Now, I'm glad to see that Mr. Watkins has now started to fill that chair. That's great. That's a helpful perspective. Very glad that he's been coming to the meetings. But ultimately, and I could say a lot more, but I'll just wrap up. I believe, I've come to believe, in discharging the Supreme Court's delegated regulatory functions for a long time now, that a governance structure that is composed solely of lawyers elected by those who are regulated as a constituency is not the best structure for delivery of legal services, for protection of the public, and for assuring access to legal services by consumers. And I hope someday, maybe 20 years hence, that we will re-engage with questions about the structure of bar associations, whether or not the United States Supreme Court says we have to.
Hello, my name is Kevin Michael Watley, and I appreciate the opportunity to be able to speak here. And I really just want to help reiterate what the Office of Disciplinary Counsel, Mr. Ende, said, that as a victim of malpractice as an attorney, and as a member of the 7.5 million people of Washington who bear the burden of that flag that this bar is supposed to help protect, that it was created by the Washington State's legislature as an agency of the state, and its first duty, first and foremost, is to the public and access to justice so that all people can be seen as an equal under the law. And when every major European country has basic public protection system of mandatory malpractice insurance, it speaks glaringly to the access to justice that the people don't have. And to that empty seat that's not here, that empty seat is because we don't have actually a voice at the governance level. So when we talked about, as Mr. Ende says, missing the mark on how we can reorganize these structures to help institutionally protect us better, to help institutionally allow access for justice, to help institutionally change the inherent system of over 100 years, over 100 plus years, that has failed to thoughtfully look at how to self-assess itself and not be fearful of losing power, but how to share that power with other people. And these aren't my thoughts. In fact, it's a former president of the Board of Governors who actually wrote in and said that the Supreme Court should adopt and recommend and include lay people on the Board of Governors. Because when you have a diversity of opinion, when you have diversity of leadership, diversity of different backgrounds that aren't legal professionals, that's actually how you can engage the public, how you can engage the legal system, because the people, the 7.5 million of us, we all believe that we should have an equal access to justice by having an equal seat at the table, to have an equal voice in helping to shape the institutions and the laws that are designed to protect us, the things that we go to attorneys for. So I want to thank each and every one of you for your time here. I want to thank you for your leadership here. And I want to say that I see you not as lawyers and as judges. I see you in your first position in life, and that is equals. And as equals, I'm asking you to be advocate for all the rest of the equals of the people of Washington State. So thank you, and thank you, Chief Justice Fairhurst. I am incredibly grateful that to be under the stewardship, and the people of Washington are generally in a better position with you on the bench. So thank you, ma'am.
Jean McElroy. I am not going to give my title because I'm not speaking as my title. I am speaking on a personal basis. I can tell you that I have worked with the Bar Association for almost 30 years. And I can tell you that I've seen it through a lot of changes. I've seen a lot of different things. I know that the organization can be strong. I know that the organization is not perfect. And I'd like to echo what Doug has said. I'd like to echo Mr. Watkins. Every regulatory is that your right name? Watley. It's okay. Watley. Sorry. Sorry about that. It's all right. Every regulatory board that I've ever worked with here at the Bar Association has had public members on it, and they do provide a voice that is very important. I fail to understand why that would be so difficult for the governing structure, and that's the piece that you folks have not gotten to. I noticed that the State Bar Act has almost completely been overridden by court rules, except for the governance structure of the bar. And that was one of the driving forces for this work group, if I remember right. And so I wanted to point out that there is a big piece of what you haven't done. There is a big piece that's missing off the Board of Governors. And I think it would be very important for this work group to say something about the governance structure of the bar. Thank you.
Thank you. We've got 2 more minutes, and we're on stretching it too. You're waving to me for microphone. All right, I'm going to allow 2 more minutes if anyone else wishes to speak. Nope, you've spoken. I'm going to call that good. All right. And nothing coming in anywhere. All right. So with that, I'm going to 319 close the sort of the public, those present who aren't on the work group's comments. I thank you for them. And I'm going to go back to the work group to see if there is anything anyone else wishes to say or move. Andrea.
Thank you. First of all, I want to say thank you, Doug and Jean, for your comments, and thank you, sir, for yours as well. I appreciate those comments. When we took the vote about determining whether or not we were going to maintain our present structure or look at hybrids, I remember saying, okay, fine, but I wanted to make sure that we were still going to have the conversation about the governance structure. And I agree with you both and all of you who've expressed comments that that is a piece that we have not gotten to. At the last meeting, we started to get there, and I know that there were some motions related to it, and I know that I made some comments to the effect of that as well. And so I guess before I resolve to be dissatisfied on that issue, I guess I'd like to inquire as to if we will get there and how you envision us being able to address some of those things, because I don't want to necessarily take up time to rehash the previous comments, but I absolutely agree, and I take to heart governance structure is composed solely of lawyers elected by themselves. I always call Doug the professor. I mean, I think that's exactly right, and there were other issues that needed to be addressed with respect to governance. Again, I won't reiterate those things, but I just want to echo the concerns and just inquire about where we go with those pieces.
Well, I think we have 40 more minutes of our scheduled meeting. And if you have recommendations on governance, you should make motions and we should vote them up or down.
Thank you.
I think the Supreme Court did actually adopt language that included representation, and then it came based on the recommendation from the Board of Governors. Then it came back that was no longer the recommendation of the Board of Governors, and some of the justices who had voted for that wanted to reconsider it. And then other things were happening that led the court to believe that we should just take a break and have this work group. So if this group has thoughts as to what the composition of the governing body of the Bar Association should be, the Supreme Court, I think, would welcome those comments. When we talked about structure, as I said at the beginning of this meeting, my understanding was not that we were saying yay or nay on the Board of Governors or its composition, but we were saying 2 bars or a hybrid. And so those are still there, and you have time to make recommendations that would then go to the court. The court had its own views. The court has current views. Board of Governors, now we have new Board of Governors. They may have the same views. They may have different views. So I think it is our opportunity with the time we have left to address that, should there be any desire to. I'm going to Andre, Hunter, and Eileen. Andre.
I thank all of those who have attended and obviously spoken today. Jean, I brought up the governance issue, and I believe Mark Johnson kind of echoed that the governance piece is a part and parcel as to why we got here. But we've had the governance, we've had the report that came out in 2015. Some of it was adopted, some of it wasn't. I hearken back to a comment that Chief Justice made. She was like, hey, I've thought about disseminating that, but we've held it back to see if there were more fresh and new ideas. We really haven't provided any of those. I don't know if we're going to be able to do it in a half an hour's time as well. And so I don't know if we're going to be able to make a specific recommendation regarding governance. I know that there was a recommendation through Your Honor, Judge Corbett's antitrust memo that talked about a veto power for the Supreme Court in relation to employment and hiring decisions. I would move to adopt that or make that recommendation to the court. I would also move to have the court either re-examine or reconsider the past request to have public members of the BOG, but I also think that dovetails into a consideration of size. I run a small family law practice. We've gotten up to 4 partners, and now we're down to 3. But when you get past 5 or 6, it becomes difficult to make group decisions. As Chief Justice, I know you can may or may not want to agree with that. But certainly it does become more difficult. And if we're looking at a larger board because of the public members, I think that's a problem. I think that's something that needs to be examined and considered, and certainly this group is not going to have enough time to do that. So I would motion that we recommend to the court for public members to be considered a part of the BOG, and the second motion would be to have the Supreme Court have veto power over HR decisions or create a body or some type of decision-making mechanism to answer those issues with respect to governance.
Okay. I have 2 motions. I have 3 hands. I'm going to gather motions, and then I'll see if there's seconds, and then we'll take votes, but I'm going to go to Hunter next. And then, Kyle, I have you on the list after Eileen. Hunter, do you have anything further you'd like to say?
Well, we now have a couple of motions on the floor, so
Well,
specifically
we
with regard to the
we can
motions,
vote them up or down, but I'm thinking there might be even more. So what would
just a few
what were you going to
comments,
say?
right? Okay. So first of all, thank you, Chief Justice. I thank Doug Ende for his comments. I think he, in a more articulate fashion, explained some of the thoughts and reasoning that I had when we took the vote a number of weeks ago regarding the fundamental structure of the bar. So I think that is very helpful. I think we are facing, to Andrea's point, about the additional issues that we may or may not have been able to take on. I think we now face a tyranny of the clock issue in the sense that we've been meeting for quite a while. We're in roughly the last half an hour of the last meeting, and it looks like we're circling back to some ideas that have been discussed before. I guess I have some concerns with that it seems to indicate, at least in my mind, a bit of a lack of focus for us. We spent the better part of the last several meetings talking about Keller, and I've made a couple of Keller motions, or at least I've offered them. And so I see us in a bit of a tug of war for limited time. And so I guess that's my observation.
Okay,
Thank
so well, others can comment whether they think we should try to do it in the time we have. If you want to have another meeting, if you don't want to address governance, these are all things that are before us. I would ask you when you're making your comments that you think about the time you're taking of the time we have so that we can at least consider what we do have motions on. Eileen.
Thank you. I would I think we need to finish Keller. We've spent a lot of time on it. There's been a lot of discussion. The court may not be sitting by the phone waiting for our recommendation, but for the sake of completeness, I would hope this could be fairly brief, and I would make essentially Hunter's motion, except instead of using Keller, or strict, excuse me. Yes, we will use Keller. Instead of using strict, I would recommend that it say thorough Keller interpretation. So, because I think there has been a line of cases subsequent, and those need to be considered when looking at how to develop a formula. That would be my motion.
So that's motion number 2 of what was sent out as Hunter's motions, substituting thorough for strict.
Correct.
Okay.
And I've probably gone out of order here. I have some concerns about, in the last 31 minutes, making some pretty significant structural recommendations that I have read the governance report. What? Well, they are just, but it's been a while, so I don't feel that I've enough of a comfortable background. I would repeat the concern I had when Judge Corbett made the memo with the recommendations about hiring and firing decisions, that when you move the bar so tightly under the control of the court, what are the restrictions on judicial speech that begin to be applied to the state bar? I think that once effectively the court were to be hiring and firing or making decisions about out firing, that you really create a concern that in fact the bar works for the court and just like its employees is subject to some pretty strict restrictions in Washington, which does not have partisan judicial elections, fortunately, unlike a lot of states, say Texas. So that's all of my thoughts in one
Thank you.
ball.
Kyle?
I'd like to first say that I agree with Eileen on that last point. Earlier this year, when we were soliciting comments from the public, Chief Justice Fairhurst sent out a letter to various leaders across the state and encouraged them to comment and participate in this process. And I received that letter. I found all of the folks from Southwest Washington that were on that letter. I sent them an email and said I would be happy to, talk with you and give you an update on what has happened so far in the process. And I would encourage you to read the comments, to read the materials, and to share your input. I heard back from former Governor Loren Ettengoff, and he was frustrated because of what happened with that governance task force, which he was a part of several years ago. And he didn't want to participate in a process and devote his time and efforts to something that might take the same route as that governance task force. So I took it upon myself, because the governance task force and the report came out before I was on the Board of Governors. So I took it upon myself to go and hunt that thing down and read it cover to cover. And there are a lot of good ideas in that governance task force. For whatever reason, weren't adopted. Some of them were, some of them weren't, including the two ideas that you've just voiced today. I do think that the Board of Governors should take another look at that governance task force. These are not issues without complexity. These are complex issues. It's not just whether we think that it's a good idea to have public members on our Board of Governors. There are some complexities with that. And don't get me wrong, I do believe that we would benefit from having public members on the Board of Governors, and perhaps even triple LTs. I've mentioned this over and over again. In Oregon, they've had public members for quite some time. And I think there's 4. And they've operated very good, and they provide a different perspective. And I think that is something that we should consider. People might disagree with me, I imagine there are, but I think that should go first through the Board of Governors. We should take another look at that, and we should consider it, and then make those recommendations. And then, if the Board of Governors decides, no, we still don't like that, then maybe it's appropriate for the Supreme Court to voice its preferences. But I would like another opportunity for the Board of Governors to take a look at the entire governance task force and the report that was generated. Because as Chief Justice Fairhurst mentioned, there are new governors and there are new voices and new perspectives. And so things might be different than they were 5 years ago, 4 years ago. So those are my thoughts.
Okay, others, Fred.
I may agree with Andre, Kyle, and Eileen on all points, so let me see if I can make it a little shorter. I think Kyle said he would like the Board of Governors to take a fresh look at the previous report. I support that, but I'd also support the Supreme Court taking a fresh view of that report. Great minds spent a lot of time and a lot of work coming together with it, and I've looked at it closely, and I think it deserves a reread. Consistent with that, I would, if it came down to this, if we had time, second Andre's two motions. But I think that's consistent with the first point that I said, is that somehow looking at the governance issues, we haven't discussed those. We started talking about it at the beginning. Then the last point that I would like to make is, as to the other issue that we've looked at, or one of the Supreme Court's precedent issues that we've looked at, we've discussed those carefully. We spent a lot of time on it. Unlike the governance issues, we have studied, and I feel that we are in a position we can make a report. I might have worded Eileen's and Hunter's motion a little bit differently, but I support the idea that we need to not have a strict review, that we're strictly determine that we're following Keller. Or that we, put loaded language in there. But a lot of members do believe that the small deduction, they just can't believe it. So somehow, without prejudging it, that we do need to look to make sure, whether it's audit or review or whatever, look at the Keller deduction. So I'd probably come down to where I would second Andre's motions and I would second Eileen's. And I follow Kyle's suggestion. And maybe Kyle's suggestion is that we don't vote on Andre's motions today, but that we suggest that they continue to be reviewed.
Okay, I have Dan has a comment. Dan Clark, Margaret. And I took all of Fred as seconding the three motions that are on the table.
Can I just add?
Yes, Fred, you
okay.
can finish.
And I was, with Doug and the public comment, I don't know how we say this, but I do think that we need to continue to look at what structure will best serve the public. And I think that's included in Andre's view. And if that's not, that's why we're looking at this structure, is how to best serve the public.
I'm not sure that, I would not view that as necessarily within Andre's as currently written, but to the extent that is a different motion that can be made. Because I understood it to be hiring and firing of HR decisions and reconsidering the request to have public members on the BOG while looking into the size.
I'll accept that as a friendly amendment to what I said.
I took it to mean my overall comments regarding protection of the public, not
Right.
necessarily my motion.
Okay,
So that's
thank
what
you.
I took that to
Okay.
mean. But with respect to continued discussions of Keller, I think we would be missing the mark if we did not acknowledge the due diligence that the current staff has done to arrive at what that deduction is. And because it's $1 or 50 cents, the work has been done. And I want to make sure that if we're saying to the court that we want to have additional work done on the Keller deduction, that it is for one or two reasons. One is that it's defensible, and two, that it's transparent. But it's not about the dollar. It's not about the dollar amount. It's really about providing additional protection from the political winds regarding these lawsuits, and also providing transparency to the members and the licensees that are paying into the budget. And so I think we've beat Keller into a pulp. With respect to my motions, at the essence of time, I would withdraw them and amend it to recommend to the court to re-examine the task force, the report on governance task force that had come out, either reconstitute another task force group or invite additional questions with respect to its relevance in its current iteration and whether or not it should be updated through additional investigation and reporting. Thank you.
Fred is the second. Are you agreeable to that as a substitution for what were the first two amendments?
Yes.
Okay. I'd like to hear what Dan Clark's comment is and then see if we can address some of these. Okay, Dan? Via Margaret?
Okay, email from Dan Clark.
Microphone.
Yeah, thank you. Email from Dan Clark regarding the motion for public members. In regard to the public members on the BOG, the Board of Governors formed a work group to study the potential onboarding of the two public members and/or one LLT or LPO member seat, which, if all three were adopted, it would raise the current number of the BOG from 14 governors to 17. A report was completed and ready to be presented at the September 28 BOG meeting, but the Supreme Court's September 21st letter from the court stayed this. I don't believe this work group is the appropriate place to make recommendations to the court. There are studies that say a maximum size of 15 of the BOG is effective. The onboarding of the three new governors was done in violation of the recommendations of the 2014 Governance Task Force, that it recommended that adding these positions with the change of the 11 congressional district seats into 9. The 2016-17 BOG simply ignored this recommendation and just agreed to add 3. This is an issue that will continue if or when the Supreme Court lifts the current stay on potential bylaw amendments. Then he addresses motion for veto powers. There is already a veto power in the bylaws. It says that for the executive director that they can appeal. The court has plenary authority over the BOG and has the ability to intervene when it feels it is appropriate. Under governance issues, I am in agreement with Kyle's comment about governance. I believe we should look to recommend to the court to meet more frequently with the BOG, to work collaboratively with the BOG on potentially looking at current governance issues and/or suggestions. Chief Justice mentioned today that the BOG used to meet with the court 2 times a year. We currently only do so once. There are a lot of good ideas in the 2014 Governance Task Force that should be revised. One was part of a previous motion I suggested regarding the elimination of the 3 and done rule in the bylaw and potentially additional extending the BOG terms from 3 to 4 years. Even if the bylaw change didn't apply to current governors who would need to roll off the BOG after 3 but would be eligible to run for future election/appointment, I think that is appropriate.
Okay, thank you, Dan. Andrea.
Just a quick comment. I'm sorry, let me just clarify. Are we speaking directly to the motion or is this open for comments in general?
Either one.
Okay, thank you. And I apologize for my confusion. One of the recommendations that came out of that task force was also that the governors be appointed by the Supreme Court. I think it's interesting that we're sort of parsing which ones we want and which ones we don't want. Secondly, we don't have a lot of time. I understand that. I think that my concern is making the recommendations or the idea that we're going to just give everything back to the current Board of Governors and sort of say, okay, now you guys just pick up and run with it. But we have done absolutely nothing to change the current status quo or to put anything in place to sort of give some guidance or assurances. I think the one thing that could be accomplished today would be the recommendation with respect to, at a minimum, the recommendation with respect to the inclusion of public members. The idea that you're going to give it back to the board as currently constituted without those members who are then going to be the deciding body as to whether or not those public members should come on board, and when that happens, that just seems problematic. If the time or when the time is appropriate, I would like to make a motion to that effect.
I took that to be a motion. So let me tell you the motions I think we have. One is to recommend to the Supreme Court that they re-examine the Governance Task Force report. That was made by Andre and seconded by Fred. The other is Eileen's to finish the Keller, which is basically motion number 2 with strict change to thorough. And then I took it sort of as Andre's reasoning is that for the reasons that it be defensible and transparent. Not that there's any question as to the dollar amount. I would add as my own separate comment, I think that goes partially to what Nancy was saying about how all of the work, that they're doing or the sections are doing on the laws and other things, and even some of the ones that I gave as examples of where there was some concern that the Supreme Court, that the Board of Governors got out in front, good arguments could be made that in fact they didn't, depending on how you interpret the language. I then have as now the third motion, the one by Andrea, which has not been seconded yet, and I'll call for a second, the recommendation to the Supreme Court that they include public member or public members on the Board of Governors, which was Andre's original second motion. Andre's seconding, which then subsumed into one, but now is back alive as its own separate. Okay, Eileen.
As I said, I read the governance report a while ago. Was there, or is there with this? Would this be by appointment, election, selection by the BOG, or was there something along those lines in the governance report?
So I can pull it up. I have it saved in here, but my guess is that it'd be by appointment because that was a similar suggestion with respect to how the other governors came on board as well.
I didn't mean you.
I'm so sorry. Did I speak out of turn?
No, not at all. Hunter had to leave for a moment because I think we're going to take votes. Where he's going, I told him to hurry and come back. All right.
And was that appointment by the Supreme Court or by?
Yes, and
right, but I understand the motion right now not to include how it's done, just that it be done.
That is
and
correct.
I also understand us not to be saying we agree or disagree with the task force report, but that it should be revisited.
Yes.
And then how the Supreme Court decides to revisit it with the Board of Governors, not with the Board of Governors, through some other group, et cetera, we are not giving that direction. The motions at this time are not giving that direction. So it was just to re-examine it because there were good ideas and time has passed. And they may be up or down, and it may involve. Now, I don't think I was aware until I'm filling a little time till Hunter comes back. What Dan said, that the Board of Governors had reached a different conclusion from when we put in the hiatus, no one ever heard, the Board of Governors was ready to come back with something different because we had heard something completely different, which is partially why we were revisiting our decision that already was a decision, which was an order, and then I had people in my office, can we defy Supreme Court orders? Which is why we put it in hiatus, so you weren't defying us. Andrea, and then Kyle.
Just very quickly, we keep hearing these comments about the size of the board, and I just want to say, like, looking at other boards, like for example, the YWCA, which is a board I've been reviewing and researching. They have 25 members on their board, and their executive director tells me they are highly functional and they're able to get the work done. I'm just going to ask that we pause and we think about what it means when we say there are too many people being included.
Okay, I had Kyle next, and then I'm going to try to move to some votes on the 3 motions we currently have moved and seconded. Kyle.
From my perspective as being on the Board of Governors when the hiatus was in place, we were having discussions about, what was appropriate. We weren't really focused on the governance task force at that time.
Right.
And perhaps we should have been. And I take Governor Clark's comments. I think they're correct. I think they should be examined in light of those recommendations. And Andrea, I accept that some boards function very well larger. Some boards, I've been on a number of boards, and sometimes the more voices you get, the harder it is to accomplish things. And I think that's part of the governance task force's recommendations as well. It doesn't mean we have to agree to accept everything in the governance task force, but it should be, I think, my opinion, it should be deliberated together. And I have heartburn about, again, what you mentioned, Andrea, is pulling out portions and not considering the whole thing. And I do think that if it came back to the Board of Governors and we deliberated about this, things might be different this time. There are new voices and there are new faces and there are different
That's what scares
opinions.
me.
Okay, we've made it almost this far, and we've really done a great job. So I think we should vote up or down the motions as written, as remembering again that they are only recommendations to the body. I think you can trust that the Supreme Court will be deliberative, that they will figure out who should be at the table, much as they have in this process. And that I will be there. We also are going to put together a report, written report, that you will all see before it is submitted. If upon seeing that you want to come back together, that's an option. So coming together in August, if there are more things you want to talk about, or you're not satisfied that we can't do it by email, then we will do that. And of course, the report will be public. It'll be available for everyone to see and read. I regret that we're at this time frame and that I did not actually provide that task force report to you. And so this is a little bit at a loss. Sounds like many of you found it, read it, have considered it. And I did in the old days and will again. But this is just inviting that a body of work was done on this issue and that we should re-look at it without saying yay or nay on any pieces of it. And that's all it's saying. Okay? So that's motion number 1. I'd like to call for the vote at this time. All those in favor indicate by raising your hand in the room. I have 7 on the phone. Jane?
Yes.
Dan?
No.
Okay, so I have 8-1. Dan Clark.
Mary, Paul Sweegle here, and I vote no.
Oh, 8-2. Great, Paul. When did you join us?
I've been on since 3, and I'm sorry I was late. I was essentially stuck up on a mountain where the weather turned on us.
Good. I'm glad you're safe and down. And we'll go now to motion 2, which is Eileen's, which is basically Hunter's written motion number 2 with the word thorough and adding the reason, not critical of what has been done, but to be sure going forward that it's defensible and transparent. Okay, everybody agree with the motion? Everyone understand it? All those in favor, raise your hand in the room. 7. Jane?
4.
Dan?
Yes.
Paul?
Yes.
Okay, so that is a 10-0. You notice my hand's not going up. I'm abstaining on all of these, so that's just FYI. The final motion was that made by Andrea, seconded by Andre, and that was to include to recommend inclusion of a public member or members on the Board of Governors. Everybody clear? Those in favor, raise your hand. 4 or 5. Opposed in the room? 2. Going to the phone. Jane?
Yes.
Dan?
No.
Paul?
No.
Okay, so that is 6-4, so it passes. The votes will be reflected, so the Supreme Court will know. The 4 dissenting being Kyle, Hunter, Dan Clark, and Paul. Paul Swagel. Okay?
Let the record reflect that those are all Board of Governors.
That is a known fact just by their names. Hunter.
I also observed the vote total there. I wanted to clarify, and I apologize if this discussion happened when I was out of the room, but my opposition is I just don't know enough about
Sure.
the facts on issue number 3. I've articulated to a number of people. I think it's vital that we receive ongoing public comment to the board. I've talked about maybe a public advisory council, but I just need more information. So that's my sole basis for opposition. Thank you.
Okay, Kyle.
And again, I'm not opposed to having public members on the board. In fact, I think it's a good idea. My own reason for voting is that I think the Board of Governors should think about this and consider it not in light of being told to do so, but we should be doing it on our own.
Okay, noted. Anything else? Any other motions? Anything else for the good of the order? Eileen? Why not? Yes. Please.
Well, I was on the 9-0 side. I figured I better get back into my usual thing. I would make Hunter's motion number 3, except I would end it after I move the bar structure group recommend to the Washington Supreme Court that the court order the WSBA Board of Governors to design, establish, and support, an oversight body of no more than 5 to oversee the Keller calculation and deduction process.
Period. Okay. All right. Everyone understand the motion? It's motion number 3 minus the such language, the rest of that sentence. Is there a second?
It's an unusual spot in that it's originally my motion, but I'll second the motion.
Okay, so I have a motion and a second. Motion by Eileen, second by Hunter. Discussion. Fred and then Kyle.
I think this is make work. I think the other motion, covers this, and I think there's, from the comments that other people have made, I think that this could lead to some unintended consequences.
Kyle.
I agree with that, too. I also question the limitation of not more than 5, since we did have a previous group. It was more than 5. So I don't necessarily agree with the limitations.
Okay, other comments? Anything from Jane, Dan, or Paul?
No, not here. Thank you.
Okay, Andrea.
This is going to be inarticulate, but I think that just in light of the where we are, in light of some of the workplace issues that got us here in terms of staff, harassment issues, and other suits, I don't know if what the court is doing, and so maybe this motion is perhaps moot, but I feel like there should be some recommendation made to the court in terms of having some sort of review of those issues and policies implemented if they are not already in place to address them. The sexual.
We have given direction to the Board of Governors to adopt such a policy, and so that has been taken care of.
Thank you.
Kyle?
And I think it's been adopted, too. We're still working on it, but the policy has been adopted.
All right, and the Supreme Court, I'm sure we'll be hearing about it when the bar is ready to tell us about it, but we have given clear direction, so yours is not necessary, but I do have a motion and a second on what was Hunter's written motion number 3 that has been partially amended. Everybody clear on the motion? A couple of people have spoken, given their comments. Andre?
I reaffirm my comments about the Keller examination already continuing to take place with bar staff and appointing the Board of Governors to design, establish, and oversight a body. I think that I don't support that.
Okay. Any other comments before we vote? Hunter, final comment?
Yeah, just a brief comment since I was the original author of this motion. I'd anticipated addressing this
Please.
a little more at length if we got to this earlier in the meeting, but the intent of this motion is in no way to throw rocks at the bar staff. And I know you get that. And I would never want that to be interpreted in that way. I presume their professionalism and their integrity when conducting this Keller examination. Instead, it's really an effort to build, promote both transparency and credibility with the members. That's really what this
Okay.
is designed to do. Thank you.
All right, so that's just a clarification. People will vote as they're going to vote. I'm ready to call the vote. All those in favor in the room, raise your hand, please. I have 2. Those opposed, raise your hand. I have 5. Going to the phone, Jane, your vote?
4.
Dan Clark, your vote?
No.
And Paul, your vote?
No.
Okay, so that motion fails on a vote of 3 to 7. The 3 voting for were Hunter, Eileen, and Jane. Okay? Anything else for the good of the order? 4 o'clock on the dot. Okay? Again, Kyle, please.
Just a question. Are we envisioning another meeting to discuss the report, or is this the last meeting then?
I am not envisioning another meeting at this time unless a member asks me to call a meeting, or you leave and you're dissatisfied that somehow we didn't do something you think we should have done, or we did something kind of like and thought, oh my gosh, that was rushed and I want to revisit it. So people, I am going to be out of state until August 1. I will have my phone and my computer, which I will check intermittently. Well, probably more often than that, but I'm going to say intermittently. And so if we needed desire that somehow we weren't done, or the report, Dory will be working on the report in my absence. I will be available when we are ready. Hopefully early August, that will come out, so that if there is a question or a concern that we can't take care of by group talk and revisions, then I sometime in August can do it. The Supreme Court meets on our administrative meeting in September is on September 4th. It is my goal that at least no later than the Friday before September 4th, which would be the 30th, going into Labor Day weekend, I believe, as Labor Day weekend, that we would have it signed, sealed, and delivered so it can go in the court's materials for that Wednesday meeting. So that's sort of where I'm working based on the feedback I got from the court that they really wanted to look at it in September, that I'll be reporting out to the Senate committee sometime, I think it's in November, as to sort of what we came up with. I imagine the court and the BOG will be having continuing discussions about last year's substitute Senate bill and what we would be looking at or not looking at. So really the court needs September, October, November to be thinking and talking about this themselves. And so that would be my goal. But I would accept and consider suggestions by any work group member that, Mary, we're not done. Mary, we missed something. Mary, we have to do something. And I would try to get as many of us as possible together in January on a doodle poll so that we could make any refinements. I think we've done really good. I mean, August. I don't mean January or July. I actually mean August because I'm out of state till August 1st. Thank you, chemo head. Or just talking too fast. So that would be my intent. I again want to thank you on behalf of the Supreme Court and myself for how diligent, attentive, careful, and thoughtful you have been during this process. This is all volunteer on your part. I've really enjoyed working with each and every one of you. I look forward to working with you in the future in a variety of capacities. I want to thank the public and the staff members and others who have attended, who have contributed, who have commented, who have presented, all of our presenters. I think we have shown how you can have thoughtful discussions in a way that you can agree and disagree, that you can be educated, that you can learn, and that you can come to resolution. And so I think we are a great example of how it can be done when so many people are not doing it these days, that we get to see in media and other places. So I congratulate us. I thank us. And as I said, I look forward to our finalizing the report, and I also look forward to getting the opportunity to work with you in the future in whatever capacities. Is your information public that you're retiring? Oh, good. Well, that's good, because I just said it. Anyway, I want to especially thank Margaret Shane for attending all the meetings and taking the notes and helping us. I want to thank Dory, who has been so essential both to my work and preparation, but for all that she has provided to this work group. So Margaret and Dory, I want to thank Rex for being with us throughout in the Rex Nolte, and I know Clay Peters helped set up today and has been in and out of the AV room. So, and thank you to the bar for making this room available and providing refreshments for us. You know, none of this happens without a lot of people working on it. So, work group members, public, staff, work group staff, thank you all. And I'm hoping I won't see you in January, but if I do, I'll look forward to that. All right? I mean, January, in August, still in August. All right, thank you. With that, we will adjourn and look forward to your comments in the future.